Why not? Yeah. Just let us test the code you just lost for this one. Good morning.
Good morning, Mr. Vincent. I can
Okay.
hear you loud and clear.
All right. Thank you very much.
All right, thank you, sir.
We'll see you later.
All right, sir.
Good morning, Mr. Ojuni, right?
No,
Yeah.
but there is a woman. My colleague here.
Okay, what's your name?
More one.
Mulan.
Agree.
Okay. How was the trip? It was sweet. Yeah. Why not do that?
Running.
Oh, you got that. Our people of work, yeah.
Morning. Good morning, sir.
We used to with Jack Better yesterday.
I was watching the, I was there.
Where were you now?
You know, I'm not.
You were not appearing with him.
No.
You came on your own.
I told him I wanted just.
Just catch on that. No.
But I saw you on it, your name on it.
Yes. I love him.
And move the place. No, let me stay back.
First on the cost list with appeal number TAT slash SSD slash 027 slash 2023. Echo Bank Nigeria Limited versus Aqua State.
More, I know. You're not allowed with
They release us.
Yes, sir.
They release me, sir.
They release you.
One has moved without paying the dog. He has moved on.
I need a convention.
No, I'm the one, sir.
Very neat.
Where is Cynthia?
She's still in the hotel. I'm checking out.
So. Appearances? Appearances? No. This one, we normally keep. Where is it? They are on YouTube and
There's a man. That's why
So maybe you should it again for a month.
appearances?
That's the man.
That's fine. Then I'm glad I will go. And then still will eat you to keep your love, you can do that another, yes. Or the year or something. Yeah, we are lead scores. They are lead scores. Appearances?
Okay.
Emmanuel.
Emmanuel, please announce your appearance.
Things.
Yeah, you're there. Let's hear you.
Announce your appearance, please. Is it that it's network is that English? It's not muted. So it's really
Is it false?
Then you should.
Check your.
Can you hear me?
No, other people are hearing us. I think it's other people are hearing. I think it's you have to log that and log back.
Call the second case.
Westfield, please, can you hear us?
Yes, we can hear you.
Call the second case.
Please, you should log that and log.
Emmanuel, you log out and log in again, if you can hear us.
Call number two.
Now one time.
Number 2 on the cost list with appeal number TAT/SSS/050/2025. Bayelsa State Board of Internal Revenue versus Westfield Energy.
Appearances? Appearances?
The tribunal be pleased. Sylvester Innocence. Sylvester Innocence.
Innocence.
Sylvester Innocence.
Yes?
My lord, I'm here with my learned friend Stanley Obidiebu.
Sabu,
Obidiebu.
Mr. Stanley.
Stanley Obidiebu.
Stanley. Obidiegu.
Yes. Commissioner.
Yes?
Our appearance is for the respondents. Westfield Energy.
Anybody for the applicant? No? No. Party reps? Any party representative? No? Where's the list? Incredible. That's it. Yes. Where is? That's a minute, gentlemen.
This is our ruling. This ruling is predicated on the application dated 22nd January 2026, filed by the applicant here. The application seeks an order amending the name of the respondents from Westfield Energy to Westfield Energy Resources Limited, and an order deeming the already filed amended notice of appeal as properly filed. Prayer 3, which was a relief seeking an order dismissing the notice of preliminary objection filed by the respondent challenging the competence of the appellant's appeal, was withdrawn by the appellant and struck out. The application is hinged on the grounds set out on the face of the motion paper and is supported by an affidavit of 18 paragraphs deposed to by Shelley Ugweke with 3 exhibits attached thereto. The respondent in vehement opposition to the motion filed a counter affidavit of 9 paragraphs deposed to by Omotola Kuni with 1 exhibit attached thereto. At the hearing on the 15th April 2026, the application was duly argued by counsel for the parties and ruling was subsequently resolved. Submission of counsel for the applicant in a short address filed in support of this application contended that the respondent was inadvertently named as Westfield Energy instead of his full registered name, Westfield Energy Resources Limited. The applicant further argued that the misnaming of the respondent amounted to a misnomer, and the respondent will not be misled or confused by the name in which it was described, as it had hitherto engaged the appellant in prior correspondences in that name, and had been so described by the Nigerian Contents Development Monitoring Board, hereinafter described as the NCDM in the publication on its website. The applicant further referred to an online search that identified or linked the respondent's office address in Lagos, Westfield Energy Lagos, and Westfield Energy Resources Limited, and posited that Westfield Energy and Westfield Energy Resources Limited refer to one and the same company. The applicant's counsel concluded by urging the tribunal to eschew technicalities and lean in favor of substantial justice, as the misdescription of the respondent amounted to a misnomer, which can be amended, and he relied on a number of cases, including Adetutu against Aderi Yumu, 1984, for Supreme Court at page 93, and the case of Adekeye against Aki Olubade, 1987, Nigerian Weekly Report, part 60, page 214. Counsel to the respondent in her written address faulted the submissions of the appellant in their entirety. The respondent argued that the misdescription of the respondent by the appellant on the notice of appeal, which is an originating process, is not a misnomer as it names a non-juristic person as respondent, and did not misdescribe an existing person. It was the submission of the respondent that the purport of the application to amend was not curative, but in reality, an attempt to substitute a doubtful juristic person for a non-juristic entity. The respondent argued that the applicant has not even put forth evidence to show that an entity known as Westfield Energy or Westfield Energy Resources Limited even existed as a site and a CSC portal does not validate the existence of any registered company bearing either of the two names as per its 01. The respondent further argued that results of casual online searches and contents from the NCNDB website being relied upon by the applicant, apart from not supporting the applicant's contention, does not amount to statutory proof or constitute evidence of registration of the entities known as Westfield Energy or Westfield Energy Resources.
counsel respondent posited that the only legally recognized proof of incorporation of an entity as a registered company was by the tendering of a certificate of incorporation as proof of the juristic status, which the applicant has failed to do. The respondent relied on the plethora of cases from the appellate courts to show that an amendment to substitute a juristic personality for a non-juristic personality in an originating process, such as a notice of appeal, should not be allowed as it does not amount to the correction of a misnomer. Counsel to the respondents concluded her submissions by urging the tribunal to dismiss the application with substantial cost as same lacks merit. Resolution of the issue. This tribunal has carefully considered the motion, the supporting affidavits, and written addresses of the parties, and is of the view that the relevant issue for determination is whether this application is meritorious and should be granted. The reasons put forward by the applicant for the grant of the application is that it inadvertently described the respondent as Westfield Energy in the notice of appeal, and that it seeks to correct that error by way of an amendment to reflect the correct name of the respondent. The respondent, on the other hand, contends that this is not a proper case of correcting a misnomer, as the name by which the respondent was sued is unknown to law, as it does not reflect the name of the juristic personality in the records of the Corporate Affairs Commission, and that the name sought to be introduced by means of an amendment does not also refer to a juristic personality known to be in existence based on the search at the Corporate Affairs Commission portal, and given the failure of the applicant to produce a certificate of incorporation confirming the existence of such an entity. Unfortunately, the applicant did not file a further affidavit controverting the weighty dispositions of the respondent, nor adduce further evidence to prove that the company with the name Westfield Energy Resources Limited, which is sought to be the replacement for Westfield Energy's existing law. The result of the search conducted by the applicant is not made available to this tribunal to confirm that indeed Westfield Energy Resources Limited is a company registered under the Companies and Elemental Act. This omission is fatal, as the only legally recognizable means of establishing the corporate existence of a company is by tendering a certificate of incorporation and not by a result of online search. See the judgments of the Supreme Court on how to prove the incorporation of the company in the cases of Apostle Peter Equezo and others against the registered trustees of the Savior's Apostolic Church of Nigeria, 2020, LBELR, page 49568, Supreme Position, and NNPC against Luton Investment Limited, 2006, 2 Nigerian Weekly Law Report, Fact 965, page 506 at 527. According to the court, it is tried law that the only way incorporation of a company can be established in any procedure is by tendering the certificate of incorporation. The only online site that can be of any help is a search on the portal of the Corporate Affairs Commission, which is a recognized regulatory agency, sees of the records of all registered business entities in a search result from the CAC Corporate Affairs Commission portal, as shown in Exhibit 01 attached to the respondent's counter affidavit, does not show that Westfield Energy or Westfield Energy Resources Limited are known to be registered entities in the Corporate Affairs Commission records as at March 2026, when the respondent's counter affidavit was filed. As earlier indicated above, the failure to controvert this material deposition by the applicant is fatal to the applicant's application. See the cases of Olakende against EFCC 2025, 17 Nigeria Weekly Report Part 2014, page 241 and 282, paragraph C12. Supreme Court. Semi Alu Adekunle 2006, 7 Nigeria Weekly Report Part 980, 551 and 561, paragraph B2B, on the consequences of the failure to controvert material depositions in the counter affidavit. The tribunal has equally reviewed the very relevant cases of Anene against MTN Nigeria Company PLC, 2025 LPEL 81713 Supreme Court, page 27 to 30. Calabar Municipal Government against Honesty, 2022 Nigeria Weekly Report, part 1815, page 403, by page 432. Unity Bank PLC against Aqua Construction and Trading Company Limited, 2025 Nigeria Weekly Report, part 1992, pages 211 and 257 to 259, as well as the decision of this tribunal in its unreported ruling in CAT South Zone 208-2025 between Bayelsa State Board of the Kenya Revenue against Losses Supermarket, cited by the respondent. The cases cited by the respondent are some of the latest decisions of the Apex Court centered on the subject matter in this application, and we find them to be opposite and binding for the proposition of law that they enunciate, and find no reason to depart from this. And the previous decisions of this tribunal in a similar matter involving the appellant here and losses will matter. The common position in the aforesaid cases is that an amendment will not be permitted to substitute a non-juristic person with another non-juristic person, and as such an error does not amount to a misnomer. It is therefore not a simple matter of technicality as the applicant suggests. The case of Calabar Municipal Government against Honesty Supreme even goes further to say that where reasonable doubt arises as to the identity of the person sued, it can initiate the proceedings. In this case, the legal existence of the person sued as a respondent, that is West Military, is in doubt. And to make matters worse, the entity being proposed as a substitute is also doubtful, given the contents of Exhibit 01 attached to the respondent's counter affidavit, which was not controverted by the applicant. Again, the applicant did not file a claim on points of law to suggest that the cases cited by the respondent were inapplicable or decided by Korea. For the above reasons, this tribunal finds that the application of the applicant lacks merits and ought to be struck out, and it is accordingly refused and struck out. No other as to cause. This is the unanimous ruling of this tribunal.
We are most grateful. Once thank the Honorable Tribunal for a well-considered ruling of this application. We are very grateful. Thank you very much.
Okay, sorry. Mr. Sylvester, Innocent.
I'm here.
The respondents are yeah. So we take a date. You have a pending application.
But I didn't get that, sir.
You have a PO pending.
There's a PO.
Okay, very well, Honorable Commissioner. The PO, I think it has actually been taken over
you
by since the matter has
ready?
been struck out. Yes, we want to withdraw the PO. Since the application has been struck out for them to amend.
Okay, you want to withdraw the PO?
No, we'll take a date. We'll take a date for that.
A date for what?
We'll take a date for hearing of the PO.
Right. Let's see. You have how many parents? You can close it. You can close it.
18th.
18th June.
18th of June.
18th.
Of June, sir.
Why is
As the traveler is. Is it of June? Honorable Commissioner, I want to know if it's 18th of June.
Yes.
Okay, thank you very much.
this case is adjourned to the 18th of June 2026 for hearing of the preliminary application.
As the traveler is.
Let's go back to number 1.
Number 1, the conflict of P number 380/NZS/27.323. Ecobank Nigerian Limited from Apple National Revenue Service.
Yeah, available now.
Yes, the Honorable Tribunal, if I can be heard clearly.
Okay.
Very well. May it please the Honorable Tribunal.
Yes.
Appearing before you is Emmanuel Ike Dinobi. Ike Dinobi. IKEDINEOBI.
Yes.
Yeah, my humble appearance. Yes, my humble appearance is for the appellant. May it please the Honorable Tribunal.
Any respondents? No? Any party representative? This is our judgment. The appellant is registered under the Companies and Other Matters Act 2020 and licensed to carry on the business of banking in Nigeria, including acquired states. The respondent here. On the 7th of October 2021, the appellant received a demand notice dated 6th of October 2021 from the respondent demanding the payment of 117,396,448 naira 32 kobo. In outstanding withholding tax on credit interest for 1999 to 2020, inclusive of penalty and interest. After some objections by the appellant, the respondent sent a revised assessment notice dated 3rd December 2021 for the sum of 102,693,607 naira 15 kobo as outstanding withholding tax on credit interest for 1999 to 2020 year assessment, inclusive of penalty and interest. The appellant objected for revised assessment through its letter of the 9th December 2021. After some further correspondences from the appellant to the respondent on the 9th June 2023 issued his notice of refusal to amend on the appellant. Being dissatisfied with the revised assessment notice of the 3rd December 2023, and the notice of refusal to amend dated 9th June 2023, the appellants appeal to this tribunal. From the notice of appeal filed on the 7th July 2023, the grounds of appeal are as follows. There are 10 grounds of appeal, though misnumbered as 11. We take the grounds of appeal as well, because it's 11 and 2. We take the grounds of appeal as well. Grounds of appeal 11 cover about 7 pages. Grounds of appeal and the release. The witness statement on oath of Mike Mirabel Uwazi, filed along with the notice of appeal, was replaced with the witness statement on oath of Adekunle Adedayo, sworn to at the tribunal registry on the 15th September 2023. The respondent's reply acknowledging receipts of the notice of appeal was filed on the 2nd April 2025, with the witness statement on oath proposed to by Lawrence Ekpudo, the head of the Directorate of Enforcement, Recovery and Intelligence of the respondent. Both parties adopted their witness statements on oath. While Adekunle Adedayo testified for the appellant, Lawrence Ekpudo testified for the respondent. The parties also adopted their respective final written addresses on the 19th of January 2026, and this appeal was adjourned for judgment. Issues for determination. Two issues were formulated by the appellant and adopted by the respondent for the determination of the tribunal. The two issues are formulated as follows. 1. Whether from the facts and circumstances of this case, the revised assessment notice dated 3rd December 2021 and the notice of refusal to amend dated 9th June 2023 ought not to be set aside. 2. Whether the appellant is entitled to the relief sought in its notice of appeal. Submission on the issues by the parties. The appellant. Issue 1. On this issue, the appellant raised a tripod argument. The first leg of the argument is whether the respondent was right to issue the revised assessment for 1999 to 2014 in view of the 6-year statutory limitation provided by Section 55 of the PIPA 2021 as amended, in the absence of fraud, willful default, or neglect on the part of the appellant. The appellant's submission is that the period covered by the revised assessment is with Echo 7 is statute by. The appellant contends that by virtue of Section 55, once a taxpayer has made returns as required by law, no additional assessment have been made after 6 years from the expiration of the year of assessment, except where there is fraud, willful default, or neglect on the part of the taxpayer. The appellant submitted for that in this appeal, the respondent has not established willful default or neglect, and the appellant has not been convicted of fraud by a court of competent jurisdiction. So the further submission of the appellant that the additional assessment made by the respondent is therefore invalid, unjustifiable, and without any legal basis. So the further submission of the appellant that when the respondents issued the notification of forensic investigation, basically Echo 1, dated 18th of August 2021, the appellant objected through exhibit Echo 14, dated 15th September 2020, on the basis that it was statutory. Further, that through the appellant's objection of the 20th October 2021, exhibit Echo 6, the appellant voluntarily disclosed an unremitted withholding tax of 3,259,218.33 kobo for the 2020 year of assessment, which it paid as shown in exhibit Echo 18, and that the disclosure and payment shows transparency and good faith on the part of the appellant. The appellant also submitted that it is the duty of the respondent to prove fraud, willful default, or neglect, as alleged by the respondent, as provided by Section 131 of the Evidence Act 2011, and that the respondent's witness statement on oath and the oral testimony of the sole witness, Lawrence Ekpudo, mainly repeated the respondent's assertions without cogent evidence of deliberate concealment by the appellant, as can be seen from his letter of 18 September 2021. That is Echo 3. The appellant also drew the attention of the tribunal to the following exchange between the appellant counsel and the respondent's sole witness. Appellant counsel, in your letter of December 3rd, 2021, is with Echo 7. Please show the tribunal where you alluded to the issue of fraud, willful neglect against the appellant. The answer from the Answer: there is nothing about fraud in the letter. The appellant therefore submitted their assertions, no matter how forcefully, do not transform into evidence. I refer the tribunal to the case of Delta Africa Engineering Nigeria against acquired from State Board of Internal Revenue, 2022, for Nigerian Pass Law Report at page 115, where the court held that suffice it to say that it is not enough that fraud is merely alleged. Fraud is a serious crime, and in civil matters, the particulars must be pleaded and proved strictly. It is also tried law that a person alleging fraud is not only required to make the allegation in his pleadings, but must set out particulars of facts establishing the alleged fraud. The onus of establishing fraud, willful default, or neglect is upon the court. It cannot be established by presumption of guilt. The appellant also referred the tribunal to the case of Otukpo against John and another 2012 LPELR 25053 Supreme Court, where the Supreme Court held that fraud must be specifically pleaded and must be proved beyond reasonable doubt. The appellant also submitted that the Nigerian courts have exercised their limitation provisions in passing statutes are mandatory and binding. The appellant referred the tribunal to the case of Shell Petroleum Development Company against FBIRO 1996, 8 Nigerian Weekly Law Report, page parts 466 and page 256, where the Court of Appeal stressed that passing statutes must be construed strictly, and any assessment not supported by law is void. And the case of Umonam Nigeria Limited and another against section 2012 LPELR 20037, where the court held that without proof of fraud or willful default, assessments outside the limitation period are null and void. The appellant submitted for that while the 1999 year of assessment expired in 2005, the 2014 year of assessment expired in 2020. But the respondent in December 2021 imposed additional liability for those years in violation of section 55 of the Peter 2011 as amended. In spite of there being no hidden accounts, no falsified returns, and no deliberate concealment on the part of the appellant. There was no proof of the assertion of fraud and willful neglect. And this, the appellant likened with what Ofuta JSC of Blessed Model termed IFC disease. In the case of deaths against Senico Limited 1986, 3 Nigerian Weekly Report part 32, page 846, at 853 to 854 paragraph 8, the Supreme Court held us. Now, IFC deceit literally means he himself said it. It is thus a bare assertion resting on the authority of an individual. There can be no question that the mere IFC deceit is admissible, but it is evidence resting on the assertion of the one who made it, where there is need to further proof the mere IFC deceit may not be enough. The Ofuta JSC of Blessed. The appellant also submitted that causation must adhere to the principles of certainty and fairness as enunciated in Adams Smith's Canons of Causation 1776 and applied by Nigerian court in the case of MTN and BIROS 2021 LPELR 56259 Court of Appeal, where the Court of Appeal held that the requirements for efficient administration consist of some values such as clarity, stability, cost effectiveness, and promptness. The modalities for assessment and payment, time and occasion for tax payment must be clearly stated in the law for enforcement. It cannot be arbitrarily done, as taxpayers must not be subjected to indefinite audits or unpredictable liabilities. The appellant further submitted that to allow the additional or required assessment will amount to subjecting the appellant to indefinite audits. Unpredictable liabilities are not justifiable assessment. The appellant therefore urged the tribunal on this subject to hold that the revised assessment of the 3rd December 2021 for the 1999 to 2024 years of assessment is statute barred and void by virtue of section 55 sub 2 of the Peter 2011 as amended, and allow the appellant's appeal on this ground. The second leg of appellant submission on issue 1 is that the respondent is stopped from reopening the 2002 to 2016 year of assessment, having concluded satisfactory audit and issued final and conclusive assessment, which were fully settled by the appellant. The appellant's submission is that the respondent had issued demand notice dated 12/12/2019, acknowledging reconciliation for 2002 to 2016. Demand notice dated 12/12/2019, captioned final and conclusive revised assessment, fixing liability for 2002 to 2016 at 20,306,099 naira 3 kobo after penalty waiver of 75%. And final demand notice dated 19/11/2020, captioned final demand notice on withholding tax 2017 to 2019, fixing liability at 10,679,573 naira 37 kobo, which the appellant paid as evidence on exhibits ECO 9 and ECO 18, which renders invalid the respondent's reverse assessment dated 3rd December 2021, exhibit ECO 7, which was completed by the appellant's submission dated 9/12/2021, exhibit ECO 8, on the doctrine of contractual estoppel and the provisions of the PITA 2021 as amended. It is the appellant's further submission that, having accepted and represented the appellant's liability for the affected years as final and conclusive, and having received payment, the respondent is contractually stopped from reopening the assessment for the same people. The appellant further submits that the respondent, having not denied the position in paragraph 13 of his witness statement on oath, and the vivid explanation of how he remitted his past liability for the 2002 to 2016 and 2017 to 2019 to the respondent. The respondent is deemed to have admitted those facts which need no further proof by the appellant. The appellant referred the tribunal to the case of NAS Limited against UBA PLC 2005, 14 Nigerian Weekly Law Report Part 945 at page 421, to the effect that facts which are admitted by an opposing party require no further evidential proof. The appellant drew the attention of the tribunal to the fact that the outstanding tax liability of 10,679,573 naira for 2017 to 2019 was paid in 2 tranches of 7,806,007 naira 65 kobo paid on 21st December 2020, and 2,873,516 naira 72 kobo paid on 30th March 2021. Under the payment narration for payee, because the initial demand notice was for payee and withholding tax, the appellant urged the tribunal to consider the 2 payment receipts attached to the notice of appeal as they form parts of the tribunal request, and relied on the case of Adekunle against Ademola 2021 for Nigeria Weekly Law Report Parts 1767, page 399, where the Court of Appeal held that the Court of Law is bound to look at and act on any document or process filed or content in its record. In other words, the court is entitled to look at the contents of this file or records and to take it in consideration of any matter before it. This it will do to obviate injustice. The appellant submitted for that his tax liability to the respondent for the 2020 year of assessment was paid as evidenced by the ECO 13. Also, the appellant submitted that where parties reconciled and the taxpayer paid to liability, the tax authority is bound by the reconciliation and relied on the case of FBIR against Confidence Insurance 2010 2 Tax Law Report of Nigeria, page 96, where the court held that where a taxpayer and the tax authority agree as to the liability of the taxpayer will fully be liable to pay the tax agreed. The appellant further submitted that the tax appeal tribunal in similar circumstances to the case of First Bank of Nigeria Limited against Imo State Internal Revenue Service, this ruling of 7th of September 2012 relied on the principle and stated that it is absolutely imperative that the sanctity of agreements be respected. It will be against public policy and the interest of the society for a government agency to commit itself to a particular course of action and without reasonable cause, drainage, or depart from it. It is of public interest that there should be an end to this situation. The TAT borrowing from the Latin Museum, Nemo, Davis, the Mesarium. Nobody should be very angered twice. Rule that in the absence of fraud, willful default, or neglect, the respondent is barred from inquiring by way of assessment or investigation or by any other means from the appellant contents of his records beyond 6 years from the dates of assessment. It was the further submission of the appellant that section 55 sub 2 of the Peter 2021 as amended restricts bank duty investigation to 6 years, except where the authority can establish fraud, willful default, or neglect. The appellant referred the tribunal case of Delta State Board of Internal Revenue against EcoBank PLC, TAT South Zone 005-2020, where the tribunal held that a tax authority which had already audited a taxpayer and issued assessment cannot conduct repetitive audit of the same period without proving fraud or willful default, and that the burden of proof rests on the authority. Also in Citibank Nigeria Limited against River State PIR, TAT South Zone 017-2018. The appellant submitted that the tribunal held that additional assessment outside the 6 years window are unenforceable where the tax authority merely alleges neglect that produces no credible evidence. To further press these points, the appellant also referred the tribunal to the case of John Kawan Wolf Company Limited against Federal Board of Internal Revenue. All NCC 42 page 102. The appellant urged the tribunal to hold that the respondent is stopped from reopening already reconciled and closed assessments. On the final and third leg of the appellant submission on issue 1, the appellant contends that the respondent unlawfully applied 21% and thereby levied arbitrary penalties of 20,207,541 an interest of 2,435,000 naira and 1 naira 13 kobo, and that the assessment is an abuse of discretion. The appellant contends further that the respondent failed to use the correct data in computing the tax liability of the appellant and did not take into account the remittances and documents furnished by the appellant. Instead, the respondent recomputed liabilities as if the remittances were never made, leading to duplication and inflation of the alleged tax liability. The reassessment therefore violates section 54, sub 2 of the Peter 2021 as amended. The respondent resorted to BOG assessment. They refused to furnish the appellant with the information he used to arrive at his BOG assessment. The appellant also submitted that a BOG assessment should not be arbitrary, be reasonable, and must not be made in disregard of the documents and information provided by the appellant. The appellant referred the tribunal to the case of Nelson Petroleum Nigeria Limited against LSIRS 2019 44 TLRN, where it was affirmed that place of judgment should only be resorted to where the taxpayer fails to file returns or file an inadequate returns, and that in doing the assessment, the assessing authority must base its decision on the principle of justice, equity, and good conscience. In common parlance, the words place of judgment carry the connotation of what is best in the circumstance. Whereas in this case, the tax authority abandoned the documents submitted by the taxpayer and resorted to the use of discretion in the form of place of judgment. It cannot be said to be proper in the circumstances. Similarly, in FRS against Low Oil and Gas Nigeria Limited 2016, 24 TLRN, the tribunal did not hesitate in setting aside the BOG assessment on the appellant for being unjustifiable, unreasonable, and arbitrary, when it declared as follows. Base of judgment assessment must be fair, rational, and true to industry concern. In FRS against General Telecom, TATLZ 004-2010 decided on 6 May 2014 This tribunal said, discretion, whether judicial or, as in this case, administrative, must be exercised reasonably and not arbitrarily. Based on judgment assessment are discretionary. Their discretionary nature does not permit the appellant to plug a figure out of thin air and fasten it on the respondent. In this appeal, the appellant simply used figures that have not been justifiably established as the respondent. The appellants also submitted that, as shown on Exhibit Echo 7, the respondent imposed penalty and interest at a flat rate of 21%, which is unlawful and contrary to Section 74, Sub 1 of the Peter 2211 as amended, which stipulates that where a taxpayer fails to deduct or remit tax, the applicable penalty is 10% of the tax due, together with interest calculated at the prevailing monetary policy rate of the Central Bank of Nigeria, in addition to the principal sum. The appellant submitted further that by using 21%, the respondent undermined the principle of legality in taxation and exposes the respondent's computation as oppressive and baseless, because taxation is strictly regulated by statute, and any penalty on interest imposed outside statutory provisions is null and void, and relied on the case of Federal Board of Inland Revenue against JSL Escala 2002 TL. Furthermore, the appellant submitted that penalty and interest arise only when the appellant has failed to challenge the assessment within 30 days, and the assessment has become conclusive, as contemplated by paragraph 18 sub 3 of the 5th schedule of the Federal Revenue Services Act 2007. In the instance action, the appellant received the respondent's NORA on the 9th, 2023, and filed this appeal on the 7th July 2023, which is within 30 days, and the assessment should be set aside. The appellant submitted also that penalty is consequential to specific breaches of the law, such as failure to remit in statutory timeline, and it is the duty of the respondent to establish such breaches because by Section 137 of the Evidence Act 2011, the burden is on the person who assigns a power to prove it. The respondent did not show by computation or documentary evidence how it arrived at 21% penalty. The appellant referred the tribunal to the case of Tetra Pak Capital Limited against FIRS 2016, 26 CLRN page 34, where it was held that penalty and interest will only apply to overdue tax payments after the tax liability has become final and conclusive, which was not so in this case. The appellant emphasized that the revised assessment is the Echo 7 is led to errors such as duplication of liabilities already settled by the appellant, unlawful application of 21% penalty and interest, contrary to Section 74, Sub 2 of Peter 2011, and arbitrary imposition of penalty without evidential proof, and therefore urge the tribunal to hold that the respondent's computation is erroneous, unlawful, and unenforceable, and set aside the revised assessment 3rd December 2022. It is a further complaint of the appellant that failure or refusal of the respondent to disclose the alleged additional information which triggered the revised assessment occasions in breach of the appellant's constitutional right to fair hearing as enshrined in Section 36 of 1 of the 1999 Constitution of the Federal Republic of Nigeria as amended. And in the case of Alhaji Chief Yekini against Chief R.O. Sumono and others, 1987, LPELR 2822 Springbok, as encapsulated in the doctrine of Audi of Captain Patent. Also, the appellant submission that the business statutory fall within the realm of civil rights and obligation under Section 36 of 1 of the 1999 Constitution, and that the respondent is an administrative body exercising partial judicial powers and is bound to accord the appellant particulars the basis of his decisions to afford the appellant a fair opportunity to respond, as was stressed in the case of Garba University of the Degree, 1986. One Nigerian Weekly Law Report, Part 18, actually 550, that even an administrative body must accord a party the opportunity of knowing the case against it to respond adequately. The applicant called in aid is case of Samson Daniel on and another against the Honorable Commissioner for Finance and Economic Development and another, Volume 4, all NCC, page 351, where the court held that additional tax assessment and penalty without fair hearing is oppressive and vindictive. And the case of Chief Williams FRA against Adelaja FAI and another, Volume 1, all NCC, page 210, where the court emphasized that the tax authority must give adequate opportunity to the taxpayer to defend his interests. And in addition, the partial judicial power was be exercised judicially, as was held by the Supreme Court in the case of Adigman and Controller of Oyo State, 1987, one Nigeria Railroad property at the C7. Any decision which in breach of failure systematically void, regardless of whether the decision might have been otherwise correct. The appellant also drew the governor's attention to the fact that the appellant had requested from the respondent information which formed the basis of their assessment. But the respondent refused. And upon examination, the respondent merely claimed that the information was classified. In the appellant counsel view, such information cannot be treated as classified because it's related to the appellant's rights, and the tribunal was urged to accompany the respondent's testimony. The appellant submitted further that the respondent deliberately withheld the information because it was unfavorable to the respondent and relied on the case of Alibi against the year 2002. One Nigeria will be part 747 at page 280. The appellant or the tribunal to resolve issue 1 in favor of the appellant and to set aside the revised assessment. Issue 2. Or whether the appellant is entitled to the relief sought in his notice of appeal. The appellant submitted that it remitted all its tax liabilities to the respondent, and that it is no longer indebted to the respondent, and that it shows this true cogent and credible evidence. In the appellant's view, the respondent's case further strengthens the appellant's case when the respondent should identify the appellant's payment receipts. In his further submission, the appellant is of the view that the assessment covering 1999 to 2014 is certified and borne out from the appellant's evidence and corroborated by the respondent's witness on that when the respondent witness said that there was no fraud or willful. The appellant summarized submissions as follows. A. The revised assessment and NORA arbitrary and unjustifiable having disregarded prior reconciliations and full payments from 2002 to 2016 and 2017 to 2023. B. The reassessment for 2002 to 2020 amounts to double assessment. C. The assessment for 1999 to 2014 is started by under section 50 of the Peter 2011 amendment. B. The penalty and interest of 21%, that is the Echo 7, are unlawful and start contrary to section 74 of 1 of Peter, which prescribes 10% penalty plus interest and the prevailing monetary policy rate of the CBN. E. The respondent's refusal to disclose the source of this additional information relied on to raise the reverse assessment in spite of repeated demands in its list, Echo 2, Echo 6, and Echo 8, occasionally a breach of appellant's constitutional right to fair hearing under section 36 of 1 of the 1999 Constitution. In his final submission, the appellant urged the tribunal to grant the relief sought in his notice of appeal. The respondent on issue 1. On issue 1, the respondent made the submission that for submission. A. Whether the discovery by the respondent of a significant multi-year and systemic underinheritance of withholding tax on credit interest by a corporate taxpayer such as the appellant does not, in and of itself constitute prima facie evidence of willful default or neglect, by comparing the respondent under the express provision section 55 sub 2 of the FITA to conduct a validity investigation and raise assessment for the years 1999 to 2020 in order to make good the substantial loss of public tax revenue. The respondent submitted that the appellant submission that the assessment for 1999 to 2014 is by is a flawed and restrictive interpretation of the proviso to section 55 sub 2 of FITA, because the appellant cannot conceal his non-compliance for 6 years and then claim statutory limitation, thereby profiting from his own wrongdoing. It is the further submission of the respondent that a foundational principle of taxation in Nigeria, as enshrined in section 24F of the 1999 Constitution, mandates every citizen to declare his income honestly, appropriate and lawful business, and pay his tax promptly. And that this underpins all tax contributions and highlights the societal importance of tax compliance. The respondents called the case of independent television radio against ESBIR 2015, 12 Nigerian Weekly Law Report 5, 1474, at page 442, where, according to him, the court emphasized that a citizen's failure to pay tax will result in the forfeiture of constitutional protections and describes such non-compliance as despicable and seriously detrimental to the development of the nation. The respondent also submitted that willful default in the remittance of taxes implies a high degree of complicity on the part of the taxpayer going beyond mere error or oversight. In his persuasive argument, the respondent referred to the case of Idaman Kamoni SDM against Ketua Pengara Pasil Dala, Nigeria, 2022, where the Malaysian High Court held that to establish willful default, it must be shown that a taxpayer failed to exercise due care in completing a relevant task, possessed knowledge of committing and intended to commit a breach of their statutory duty. Alternatively, acted with reckless carelessness, meaning they did not care whether their act or omission constituted a breach of duty. The respondent, therefore, submitted further that willful default is characterized by deliberate intention to breach tax obligation or a conscious and reckless disregard for those duties, and shows a state of mind where taxpayers either know they are violating their duty and intend to do so, or act with such indifference to their obligations, which amount to intentional breach. The respondent also submitted that neglect is failure to exercise a degree of care which a reasonably prudent person would have exercised under the same circumstances, and that in tax matters, it translates to taxpayers failing to perform their statutory obligations with reasonable diligence, even if there was no deliberate intention to evade tax. The respondent is of the view that in the present circumstance, the appellant failed, neglected to remit the accurate withholding tax on credit interest for the 1999-2020 period, which is evidenced by the appellant's disclosure of previously undisclosed and non-remitted withholding tax operating interest of 3,259,280 naira 33 as shown on this basis. The respondent also submitted that the appellant willfully, intentionally, and voluntarily failed, refused to disclose all requested information and remit the taxes due to the respondent, and that this constitutes willful default, which formed the basis for the issuance of the NORA of 9th June 2023, as shown particularly the second paragraph of the letter. It was a further submission of the respondent that the delivery of the payment of the withholding tax operating interest, failure and refusal to avail the respondent with requested documents amounts to willful default, and contrary to section 47 of the FITA 2011, and a breach of statutory duty. It is also the respondent's submission that, in spite of multiple letters, requests, and meetings, the appellant failed and refused to provide a complete set of documents requested, evidence by the respondent witness statement on oath, and under cross-examination, particularly the second part of paragraph 18 of the witness statement on oath. The respondent urged the tribunal to hold that the period 1999-2014 was not settled by, and the additional assessment should be upheld. The respondent again submitted that laws should be construed strictly and referred the tribunal to the Court of Appeal decision. In the case of Nirvana Oilfield Services Limited against FIRS 2022 LPEL 55812 Court of Appeal, where the court held as follows. In Federal Board of Inland Revenue against Bottom with Account Limited 2016, for Nigeria Bureau by Part 15015, page 53. This court, page Joseph Ikias JCA, has stated entirely endorsed. It is now obvious and settled that tax laws are construed narrowly or strictly sticking to the ordinary meaning the West use there without adding any clause on them. It is a further submission of the respondent that section 55(1) and 2 empowers the respondent to conduct additional tax assessment in the event of under-assessment, fraud, willful default, or neglect. And the respondent cited in the case of the Commissioner for Finance against Ukon 2000. For the General Report, page part 653 at this 363, where it was said that section 54 sub 1 of the personal income tax decree conferred on the tax authority power to impose additional tax on a taxable person liable to income tax if it is of the opinion that the person has not been assessed or has been assessed at less amount than that which ought to have been charged. Furthermore, the respondent cited the case of Skybank against KSIRS 2021 12 Nigeria Weekly Law Report, part 1759, at question 7, in support of the submission that a proper body charged with the responsibility of establishing whether a taxpayer has paid tax as will due is the relevant tax created by law. It is the relevant authority created by law. Where the court also referred to the cases of Oyale against Adamo 2000, one Nigeria Weekly Law Report at 8, and Shitu against NAC Limited 2001, 10 Nigeria Weekly Law Report, part 721 and page 298. The respondent concluded this leg of submission that having shown evidence of willful default and the respondent is legally authorized to carry out tax audit investigation beyond the 6-year limitation period pursuant to section 55 sub 2 of the Peter 2011 as amended. B. Whether the doctrine of estoppel or the administrative principle of the final and conclusive assessment can be lawfully revoked by a taxpayer as a shield to protect itself from liability for taxes that were previously under-assessed, particularly where such under-assessment was occasioned by the taxpayer's own failure to make a full, frank, and complete disclosure of his taxable transactions with the tax authority during previous exercises. The respondent submitted that an assessment can only be considered as final and conclusive in relation to the facts and information which were disclosed and available to the tax authority at the time the assessment was made, and do not apply to the distinguished tax liabilities which were never discovered or disclosed. The respondent relied on the Supreme Court case of Halliburton West African Limited against Federal Board of Inland Revenue 2025-01, Legalpedia 29275, Supreme Court, where the court held as follows. A holistic construction of section 26 of CITA Supras entitled the applicant to assess to tax the income of the respondent by way of additional assets where found necessary by the appellant, like in cases of discovered undeclared income not covered by the initial or first assessment or tax of the taxpayer. By making the additional assessment to tax on the undeclared income of the respondent subsequently found out by the appellant cannot be said to accuse of revisiting or passing over again the initial declared income that was earlier taxed as to amount to local taxation. And yes. Submitting for that, the respondent is of the view that though they are both Supreme Court decisions related to the provisions of company income tax, the session is in the scheme pari material with section 55 sub 1 of the PIA. The respondent again referred to the earlier decision of the Court of Appeal contained in LPIRO against an important reserve in 2014. LPELRO 24230 Court of Appeal. The respondent also submitted that the investigation which led to the additional assessment was predicated on the discovery of new facts and additional information, which revealed that the appellant's prior remittances were incomplete and remained unpaid. The respondent is also of the view that an assessment which is based on concealed or incomplete facts cannot be said to be in accordance with the law, as was decided in the case of Celebrities Restaurant against FIRS, TAC Southeast Zone 004-2020, cited by the appellant. The respondent drew the attention of the tribunal to the appellant's claims at paragraphs 4.24 and 4.26 of his final written address, and submitted that they are both misleading and aim at hoodwinking the tribunal and passing off the remittance of 10,679,573 naira 77 kobo in payment for payee tax as payment for withholding tax on credit interest. The respondent also drew attention on the tribunal to what transpired during the examination of the appellant witness as follows. Appellant counsel. In the same paragraph, you refer to the payee receipt dated 21st December 2020, paid to Akwa Ibom State IDR in the sum of 7,806,765, and another one dated 30th March 2021 in the sum of 2,873,565. The witness said yes. When the respondent, I'm objecting to the admissibility of these documents on the ground that the documents have no bearing to the subject matter of which we are for which we are before this tribunal. The claims of the respondent in all the demand notices are hinged on withholding tax on credit interest, not on payee. In the circumstances we hold the tribunal not to admit these documents, there is no nexus. The appellant counsel, I withdraw the documents. The respondents then submitted that it is an established principle of law that judicial decision must be based on evidence before the court or judicial body, and rely on the case of FIRS against Agro-Mills Nigeria Limited 2025. 1 Nigeria Weekly Law Report Part 1974 at page 649. The respondent is of the view that the two cases of LBIRO against Confidence Insurance 2010, 2 TLRN 96, and First Bank of Nigeria Limited against Imo State Internal Revenue Service cited by the appellant are distinguishable because they deal with agreements reached after a full, proper, and complete reconciliation is set, and do not apply in this present appeal, because there was no reconciliation or evidence of tax clearance letter from the appellant for the payment of the withholding tax on credit interest for the relevant period. The respondent also submitted that the case of Delta State Board of Internal Revenue against Ecobank, yes, CAT South Zone 005-2020, cited by the appellant, also inapplicable. As it is with repetitive audits, while the president's appeal is on new and distinct investigation triggered by fresh information, which reveals the inadequacy of previous exercise. The respondents did not reopen a case which had been closed. They took steps to correct the previous assessment, which was flawed from inception due to the appellant's actions and omissions. Then the issue C, whether the respondent's revised assessment is a direct consequence of the appellant's failure to provide complete and satisfactory records needed to validate their grounds of objection. It's not a valid exercise of the statutory power to assess according to the space of judgment under section 54, sub 3 of the. The respondent rely on section 54, sub 3, submitted that it has powers to issue a BOD assessment where taxpayer fails to file its returns or files returns that provides information which is incomplete, inadequate, or unsatisfactory to the tax authority. The respondent is of the view that the appellant failed to provide all the requested supporting documents substantiate subjections, and clear the discrepancies identified. The respondent referred the tribunal to and relied on the case of Candlelight Engineering Company Limited against FIRS 2023 LPELR 60682 Court of Appeal to support his submission that the respondent conducted itself appropriately in arriving at the BOG assessment under section 54 sub-2. The respondent also submitted that in resorting to a BOG assessment, the law does not require a BOG assessment to be mathematically perfect, but to be fair and reasonable, and relied on the case of Movie Nigeria against LPIR 1977, LPDLR 1884 Supreme Court. On the application of 21% interest rate, compute interest and penalty instead of 10% penalty plus interest at the monetary policy rate of the CBN as required by section 74 sub 1 of the PIDA. The respondent submitted that by the CBN communique number 134 for 2021, the NPR was set at 11.5%, and that when the applicant failed to deduct and remit the taxes due within 30 days of the taxes being due, the penalty of 10% was added to arrive at 21.5%. Though the respondent applied 21%, thus waiving 0.5% of the interest computation. On the computation of the withholding tax on credit interest liability, the respondent submitted that the addition to exhibit April 7 as schedules which clearly show a breakdown of the applicant's withholding tax on credit interest liability and computation. The respondent therefore urged the tribunal to resolve this issue in its favor. Argument on issue D. Whether the respondents, by issuing a formal notification of this investigation, exhibit April 1, engaging in extensive correspondence over a protracted period, holding reconciliation meetings and revising its initial assessment downwards in light of the applicant's partial disclosure, has not fully discharged its constitutional and statutory duty to ensure a fair hearing as contemplated by section 36 of the Constitution of the Federal Republic of 1999 as amended. The respondent's submission on this is that the principle of fair hearing, encapsulated in the doctrine of audi ulterior patent, is not a license for a party under investigation to dictate the terms of that investigation or to demand access to the investigator's case file. Further, that fair hearing only requires that a party be given adequate notice of the case against it and a fair opportunity to be heard in response, and not that the investigating authority should lay bare its intelligence, reveal its sources, or provide a detailed roadmap of its investigation. The respondent laid out the steps followed, which support his position that the respondent was given fair hearing to be as follows. Notification of forensic investigation was issued to the appellant, clearly stating the subject matter, withholding tax of credit interest, and the period under review 1999-20. Extensive correspondence was exchanged in the parties, affording the appellant the opportunity to state his case. The appellant was given the opportunity to object to the assessment, and it exercised this right on multiple occasions. Reconciliation meetings were held, providing a forum for direct engagement. The respondent revised his initial assessment downwards from over 117 million to 102 million, demonstrating that considered the information and documents provided by that. The respondent considers the above a sequence of events to amount to a fair administrative process as embodied in the case of Canova University of Degree, 1986. One Nigeria will play a report by 18 and 5. The fact that the party must know the state against it, because the appellant knew yes, we against it with absolute clarity, which is on the makers of withholding tax on credit interest for the years 1999 to 20. It is also the submission of respondent that tax authorities, like other enforcement and regulatory bodies, routinely and necessarily rely on confidential sources, third-party data, used to provide information and intelligence from other government agencies, and that to compel the disclosure of this information will not only compromise ongoing and future investigation, but could also endanger the success of such information. In the respondent's view, having been informed that the basis of the liability was a business transaction, the onus was on the applicant to produce its own records to show that the assessment was wrong, and that failure to obtain the respondent data source did not in any way prevent the applicant from using its own available data. Mobil Oil Nigeria Limited against LPR, 1977, FBELR 1884, Supreme Court. The respondent therefore urged the tribunal to also resolve this issue with the favor of the respondent. On issue 2, as formulated by both parties, as to whether the applicant is entitled to the relief sought in its list of appeal. The respondent submitted that the applicant is not entitled to any of the relief sought because the applicant has failed to show that the withholding tax on credit interest liability for the relevant years was remitted to the respondent by producing any letter of tax clearance. The respondent submitted further that the payment of 3,259,318 naira 33 covered by the applicant after receipt of demand notice from the respondent is an admission of willful default and neglect in the remittance of accurate taxes as at June. Further, the respondent submitted that the narration of the receipt for the payment of 7,806,765 crore and 2,973,565 naira 72 crore was clearly for payee and should not be passed off as payment for withholding tax on credit interest. In the opinion of the respondent, in spite of the fact that the above payment receipts are in the records of the tribunal, they do not form part of the evidence, and the tribunal cannot base its decision on extraneous matters. And the respondent cited the case of Wadi against MCC Nigeria Limited 2016, 1 Nigeria Law Report Part 1494 by 2427. The respondent also submitted a failure refusal of the applicant to avail the respondent with all relevant documents needed to validate his objection is both an act of willful default and neglect and a breach of section 47 of the Bill. In his concluding submission, the respondent urged the tribunal to dismiss the appeal and affirm the respondent's revised assessment was dated 3rd December 2021 and the NORA of 9th June 2023 because the respondent has been able to establish the following. A, the assessment for the period 1999-2014 is not started by virtue of the exceptions provided under section 55(2) of PITA. B, the doctrine of estoppel cannot be read with vectors. C, the BOJ revised assessment was as a result of the applicant's failure to produce complete and satisfactory documents. D, the applicant's constitutional right of fair hearing was not breached because the applicant was afforded reasonable opportunity to be heard. E, the applicant has failed to discharge the burden of proving that the assessment is safe. Rejoinder of points of law. The applicant submitted that the respondent's submission that discovery of fresh information automatically entitles it to local assessment beyond the 6 years retail period is untenable. In the opinion of the applicant, section 55 sub 2 of PITA sets a very high evidentiary threshold and requires proof of willful default, fraud, or neglect, and that mere administrative opinion or suspicion does not suffice. Further, the applicant submitted that past status must be strictly construed and that any ambiguity must be resolved in favor of the taxpayer. The appellant referred to the case of Attorney General of Lagos State against Eco Hotels Limited, 2018, at page 36, TLROM, page 1, Supreme Court, where the Supreme Court warned that tax authorities cannot, by administrative fiat, enlarge statutory powers. The appellant also cited the case of Citibank Nigeria Limited against River State Board of Internal Revenue, TH, the incomplete citation, where, according to the appellant, the tribunal held that before a tax authority can rely on section 55 sub 2 of the PITA, it must establish by evidence that the taxpayer deliberately falsified or concealed materials. The appellant therefore submitted that none of the issues tendered by the respondent satisfies this requirement, and that the assertion of new intelligence does not constitute evidence of fraud or neglect. The appellant submitted further that the respondent's reliance on internal classified information further underscores his failure to discharge the financial burden imposed by law and referred the tribunal to the case of Shell Petroleum Development Company against LBIRO 1996, Nigeria Woodley Law Report, Part 466 and 256, where the Court of Appeal held that taxation is matter of strict legality. Anything not grouped or expressly authorized by statute is void. In his alternative submission, it is the appellant's view that, assuming they not continue, that the appellant voluntarily refused to disclose all requested information. It is an offense that will be proved beyond reasonable doubt, and it is only after a conviction under section 47 sub-3 of Peter that the respondent can argue that the appellant's conduct amounted to willful default and or neglect. The appellant therefore submitted that without a conviction, the respondent's argument cannot stand because it has no basis to stand, and rely on the case of McFoy and UAC. 1962, 3 All England Report 1160. On whether the doctrine of electoral or administrative principle of final and conclusive assessment can be invoked by the taxpayer, the appellant submitted that all the cases cited and relied on by the respondent are distinguishable and inapplicable as follows. A. Halliburton case was a case of concealment of income, which came to light through verified foreign exchange records tendered by the board or tax authority. The respondent in this case did not produce documentary proof of concealment of withholding tax on credit. Mobile oil case. The Supreme Court held that the board may raise additional assessment when new facts are chosen, not previously determined are discovered. The additional assessment in the present case is not based on new facts, but on speculative intelligence not disclosed to the appellant. C. Both Halliburton and Mobile Oil were decided under SITA, which governs corporate entities, while PTP, personal income tax, and governs personal and withholding taxes. Decisions under SITA are merely persuasive in the interpretation of Peter. In the case of ABIR against Halliburton, which are about 30-16, 4 Nigerian Woodley Law Report Part 1501 at page 53. The Court of Appeal reaffirmed that tax statutes must be strictly construed. Fiscal statutes are to be interpreted narrowly and literally. See also at the age of state against Al-Majra UK Abiro 1985, 1 Nigerian Woodley Law Report Part 3, page 395. The appellant also submitted that by section 58(3) of the Peter, an assessment which has not been objected to or which has been agreed upon shall become final and conclusive, and thus create a binding administrative procedure protecting both parties from perpetual uncertainty. Further, the appellant submitted that, as was held by the tribunal in the case of Delta State Board of Internal Revenue against Ecobank Nigeria, TAT South Zone 035-2020, repetitive audit or assessment on the same factual basis offend the principle of certainty in taxation and amount of administrative preparation. Further, on the issuance of the guilty assessment by the respondent, the appellant submitted that in the case of Nescent Petroleum Nigeria Limited, Lagos State Internal Revenue Service 2019-44 TLRN1, the tribunal held that the basis of judgment assessment must be based on credible materials for the authority. It cannot raise on conjecture, assumption, or arbitrary limits. Also, that the Court of Appeal in the case of Nirvana of the Oil Services Interest against FIR 2022 LPEL 5881 Court of Appeal emphasized that the phrase base of judgment demands that the authority exercises judgment judicially and judiciously, that is, rationally and with fairness, not capriciously. The appellant submitted that the case of Candlelight Engineering Company Limited against FRS 2023 FPL 16682 is distinguishable the taxpayer to file returns for 5 consecutive years, which justify the invocation of Section 18 of the VAT Act by the FRS, and it is not so in the present case. On the computation of 21% penalty on interest by the appellant submitted that Section 74 sub 1 allows for a one-time 10% penalty and interest at the prevailing monetary policy rate, MPL, and that the respondents attempt to explain it in its final written address amounts to giving evidence in the written address. And counsel's address, no matter how brilliantly argued, cannot take the place of evidence. See Haruna against Katsina State, 2025 LPEL, page 80377, Supreme Court. On the number of failures, the appellant emphasized that in the case of Adigun against Attorney General of your state, 1987, 1 Nigerian Legal Report 553, page 2678. The Supreme Court held that failure extends to giving the person affected adequate information about the charge or allegation against him. Similarly, in Garba against University of Nigeria 1986, 1 Nigerian Legal Report 518 at page 550. The Supreme Court held that failure means more than opportunity to make representation. It encompasses the right to know the evidence and interest to this. The appellant of the Nigerian Public Company against Lagos State, the General Revenue Service, CAT, LZ, a valid assessment must be preceded by an open and transparent engagement on which the taxpayers are praised for the factual basis of the assessment. And the case of Attorney General Federation against Article 2007, 10 Nigerian Legal Report Part 1041, where the Supreme Court cautions that no agency may invoke confidentiality to defeat. The appellant finally emphasized that once the breach of failure is established, the entire proceedings and all decisions founded on it becomes acknowledged, no matter how well conducted. See Attorney General Rivers State, yes, with 2006. 17 Nigerian Legal Report Part 1008, page 436. And Okafor against Attorney General Anambra, 1991, 6 Nigerian Legal Report Part 200 at page 650. The appellant concluded by again urging the tribunal to resolve the appeal in this paper, as contained in the appellant's notice of appeal. Now, determination of the issues. Determination of the issues. Issue 1. Whether from the facts and circumstances of this case, the revised assessment notice dated 3rd December 2021 and the notice of refusal to amend NORA dated 9th June 2023 ought not to be set aside. One of the elements of the appellant's case has borne out from the notice of appeal, paragraph 4. Paragraph 26 of the witness statement on oath, moral evidence and final written address is that the assessment for the period 1999 to 2014 is statutory. The relevant provision of the law is section 55 of the PICA 20 as amended. The section which deals with additional assessment provides as follows. Section 55 support. If the relevant tax authority discovers or is of the opinion at any time that a taxable person liable to income tax has not been assessed or has been assessed at a less amount than that which ought to have been charged, the relevant tax authority may, within the year of assessment or within 6 years after the expiration thereof, and as often as may be necessary, assess the taxable person of such amount or additional amount as ought to have been charged. And the provision of this act as the notice of assessment, appeal, and other proceedings shall apply to that assessment or additional assessment and to the tax here under. Section 55 sub 2. For the purpose of computing under subsection 1 of this section, the amount or the additional amount which ought to have been charged, all relevant facts consistent with paragraph B of the proviso to section 66 sub 2 of this act shall be taken into account whether or not known when a previous assessment or an additional assessment on the same taxable person for the same year was being made or could have been made, provided that where any form of fraud, willful default or neglect has been committed by or on behalf of the taxable person in connection with any tax imposed under this act, the relevant tax authority may at any time and as often as may be necessary assess that taxable person at such amount or additional amount as may be necessary for the purpose of making good any loss of tax attributable to the willful default or neglect. Both the appellant and the respondent are admitted on the fact that the additional assessment for the period 1999 to 2014 was made after 6 years. The point of divergence, however, is that while the respondent is of the view that the additional assessment was necessitated by fraud, willful default or neglect on the part of the appellant contends that the facts and available evidence do not suggest fraud, willful default or neglect on his part, and the assessment is satisfied. By section 55 sub 1 of the tax authority can only assess a taxable person to tax within the year of assessment or 6 years after the expiration of the year of assessment. But the proviso to section 55 sub 2 empowers the tax authority to assess a taxable person to tax after the 6 years limitation period on grounds of fraud, willful default or neglect on the part of the taxpayer. The question to be answered therefore is whether it was fraud, willful default or neglect, which necessitated the additional assessment of the 3rd December 2021. The records of this tribunal indicate that there were correspondences, reconciliation meetings, and exchange of documents between the parties. On receipt of the revised assessment dated the 3rd December 2021, Exhibit Echo 7 from the respondent, the appellant objected to the assessment by his letter of the 9th December 2022, that Exhibit Echo 8, to which the appellant again attached some documents. Again, on the 1st of August 2022, the appellant wrote to the respondent, Exhibit Echo 9, and appealed to the respondent to review the documents and records of the bank submitted to it. From the available records, there was no further communication between the parties until 9th June 2023, when the respondent issued his notice of referral to amend as Exhibit Echo 10. Was there willful default or neglect on the part of the appellant necessitating the issuance of Exhibit Echo 7 and Exhibit Echo 10 by the respondent? From the chain of correspondences on record, we cannot see any act of neglect or default, albeit willful, on the part of the appellant. On the contrary, Exhibit Echo 9 shows the willingness of the appellant to have an amicable resolution of the dispute or disagreement. The last paragraph of Exhibit Echo 9 reads, "We appeal that the service review the documents and records of the bank submitted to it and issue the bank with a revised assessment to reflect its actual tax position in the sum of 3,259,318.33 for the year 2020 for a timely and amicable resolution of the tax audit exercise." Was there fraud perpetrated by the appellant to justify the revised additional assessment from 1999 to 2014 by the respondent? To justify the exercise of his powers under the proviso to section 52 sub 2 of the 2021 as amended, the respondents consistently said that it relied on intelligence to get this information on the withholding tax credit interest liability of the appellant The respondent did not confront the appellant with the information he got from intelligence sources to afford the appellant an opportunity to respond or discredit the information. The respondents can confront the appellant with the information without revealing the source of information. In the case of Delta Africa Engineering Nigeria Limited, Nigeria against Akwa Ibom State Board of Veterinary Revenue 2022 for Nigerian Tax Tribunal Law Report at page 115, page 124. This tribunal held as follows. Suffice it to say that it is not enough that fraud is merely alleged. Fraud is a serious crime, and in civil matters, the particulars must be pleaded and proved straight. The tribunal relied on the case of Monarch Nigeria Limited against 2012 LPE 20037 Court of Appeal, where the Court of Appeal emphasized that additional assessment outside the limitation period are null and void without proof of fraud, willful default, or neglect. Also in John Kawan Foods Company Limited against Federal Board of Veterinary Revenue, all entities. Volume 2, page 1. It was said that the tax authority has no right to review previous assessment except it can establish fraud, willful default, or neglect in respect of these assessments. We are unable to see the concrete or direct convincing evidence of the allegation of fraud, willful default, or neglect to justify the exercise of the powers conferred on the respondent under the proviso to section 55 sub 2 of the respondent to raise additional assessment outside the limitation period of 6 years after the expiration of the year of assessment. We therefore hold that the additional assessment for 1999 to 2014 is cut off by the limitation provisions and is liable to be set aside for being null and void. It is noteworthy that the respondent's additional assessment on the appellant was in place of judgment assessment, and the respondent exercised his powers of that section, the 4 sub 3 of Peter 2011 as amended. Section 54 sub 3 provides as follows: where a taxable person has not delivered within the time allowed, and the relevant tax authority is of the opinion that tax is chargeable on that person, the relevant tax authority may, according to the base of his judgment, determine the amount of the assessable total or chargeable income and make an assessment accordingly. But that assessment shall not affect any liability otherwise incurred by such person by reason of his failure or neglect to deliver the return. The respondent notice of refusal to amend was dated the 9th day of June 2023. Exhibit Echo 10. At paragraph 2 of Exhibit Echo 10, while reacting to the appellant's notice of objection dated 9th December 2020, that's Exhibit Echo 8, and Exhibit Echo 9 dated 1st August 2020, the respondent stated thus: we have noticed the deliberate failure, neglect, and refusal by your bank to provide us with the requested documents and records to validate your ground of objection after the expiration of the stipulated period. Hence, we hereby notify the bank with this notice of refusal to amend assessment. Was the deliberate failure, neglect, and refusal by the appellant to produce documents requested by the respondent? At paragraph 22, 25, and 34 of the witness statement on oath of the appellant's witness filed on the 15th September 2023. The witness Adekunle Adedayo deposed as follows. Paragraph 22. In further support of the above notice of objection dated 28th October 2021, the appellant bear an email sent on the 29th October 2021 to the respondent's official email address akirs.ng@gmail.com. Contact us at akirs.ak.gov.ng, and the emails of the principal officers of the respondent, dapookon@yahoo.com, Indito Ibaga@gmail.com, emergence@gmail.com, i.epo@akirs.ak.gov.ng. Forwarded the relevant documents for the withholding tax liability to wit the summary of the appellant's tax position, detailed computation of the applicant's the undisputed tax position, the Akwa Ibom State customer-wise interest expense pool data for the year 2020. 2020 Akwa Ibom State trial balance. 2020 withholding tax remittance receipts. And 2020 withholding tax remittance schedule. Paragraph 25. The respondents shall rely on the evidence of the audit payment of the sum of 20,306,099 naira being the outstanding liability on the withholding tax on credit interest 2002 to 2016. Evidence of the audit payment of the sum of 10,679,573.37 naira being the outstanding liability on the withholding tax on credit interest 2017 to 2019. Evidence of audit payment of the sum of 3,259,380 naira being the outstanding liability on the withholding tax on credit interest 2019, as well as the undisputed schedule of withholding tax remittances supplied the respondent during the audit exercises. Paragraph 34. That in addition to several documents, the appellants attached schedule with the objection dated 9th December 2021. Further to the above, the appellant attached a summary of the withholding tax levies for the year 2020, indicating the remittance of 52,150,322 naira and the outstanding liability, penalty, and interest in the sum of 3,259,380 naira. The latter amount was subsequently remitted on the 6th January 2022. Interestingly and surprisingly, the respondents did not deny the above depositions of the appellant. What were those requested documents and records which the respondent requested from the appellant and for which the appellant deliberately refused, failed, and neglected to provide or make available to the respondent? The documents were never mentioned or a list of requested documents tendered in the course of this proceeding. In the circumstances of this appeal, the appellant filed its returns for the relevant years. It is therefore safe to say that the respondent was not satisfied with the returns filed and therefore resorted to the best of assessment. But in exercising that power, a tax authority must act judicially and judiciously and must act fairly, reasonably, and on hard facts. In the case of Nezen Petroleum Limited against Lagos State Internal Revenue Service, 2019-44 Tax Law Report of Nigeria, page 1. The tribunal held that the best of judgment assessment must be based on credible materials and not on conjectural assumption of arbitrary. At paragraph 12 of the appellant's witness statement on oath, the appellant goes as follows: that in addition to the above, the appellant disclosed to the respondent that following the audit and investigation exercise conducted in 2020 with respect to the withholding tax on credit interest for the period of 2017 to 2019, along with a series of reconciliation meetings there, the respondent via a final demand notice dated 19th November 2020 demanded the immediate payment of the sum of 10,079,573 naira 37 as the outstanding liability on the withholding tax on credit interest 2012 to 2019, which sum had been fully settled by the appellants. The respondent did not deny or refute the above deposition. The letter from the respondent to the appellant on the 10,679,573 naira 37 is an annexure to exhibit Echo 8. This agreed sum was paid by the appellant in two tranches of 7,806,765 on the 21st December 2020 and 2,873,565 on the 30th of March 2021. And both payment transaction receipts form part of the annexure to Echo 8. The respondent has, however, contended that the payments above relate to payee and not withholding tax on credit interest because at the end of the transaction direction, there is an inscription: pay as you earn, payee taxes. In the course of the appellant's witness evidence during the cross-examination, the witness explained that the narration breach was caused by the officer who had effected the payment. We are inclined to agree with the appellant witness. No correspondence related to payee between the appellant and the respondent before this tribunal. It cannot be a coincidence that both payments made by the appellant sum up to the same amount conveyed to the appellant by the respondent in the Table 8. At paragraph 25 of the appellant's witness statement on the appellant gave a detailed summary of the withholding tax remittances made by the appellant to the respondent, totaling 596,621,184 This was not denied by the respondent. On the application of 21% on penalty and interest by the respondent, the appellant has contended that it is arbitrary and contrary to the provision of section 74 sub 1. The respondent tried in his final written address to explain how it arrived at computing the penalty and interest at 21%. At paragraph 3.37 on page 13 of the final written address, the respondent submitted thus 3.37. By the Central Bank of Nigeria Communique number 134 of 2021, the monetary policy rate was set at 11.5%. By the provisions of section 74, failure to deduct and relate taxes within 30 days of the taxes being due incurs a penalty of 10% for the tax not deducted. Therefore, 11.5% monetary policy rate plus 10% penalty equals 21.5%. The respondent, in her magnanimity, decided to calculate the rate of penalty and interest at 21%, waiving the 0.5%. We don't want to say more on this weird or rather strange mode of mathematical computation. But this is evidence given by the final address stage. There is no evidence before the tribunal on the applicable Central Bank of Nigeria monetary policy rates during the relevant years of assessment. We therefore agree with the appellant that the computation of penalty and interest was indeed and not in accordance with section 74 of the PDAM. Was indeed not in accordance with section 74 of the PDAM. The appellant has contended in this appeal that the tax assessment by the respondent is excessive, arbitrary, and oppressive, and is urging the tribunal to set aside the demand of this and the notice of refusal to amend. Paragraph 7, sub 5 of the second schedule with the Joint Revenue Board of Nigeria's Settlement of 2025 provides as follows. The onus of proving the assessment complaint of excessive or due for payment, as the case may be, should be on the appellant. This is a rebuttable presumption which presupposes that the assessment is correct and may be disputed and set aside only when and if there is proof that the assessment was raised without factual or legal basis. In BB Maritime Nigeria Limited against Empire of 2024, AT Tax Law Report of Nigeria 1/32, the tribunal held that the appellant has a legal burden to prove that an assessment is excessive. The burden is not on the respondent to prove a negative assertion that the assessment is not excessive. However, the burden can shift to the respondent, where the appellant has discharged the burden on it to show that the assessment is indeed not excessive. Also, in the case of Mobile Oil Nigeria against LPIR 1977, LPIR 188 was Supreme Court. The Supreme Court held that the onus to prove excessive tax assessment lies on the appellant. The onus of proof also means that if the taxpayer wishes the court to prove that the assessment complained of is excessive, it must produce some evidence from the appellant to decide not merely that the assessment is excessive, by how much it's excessive. From the foregoing, we are convinced and satisfied from the documentary evidence produced by the appellant in this appeal that the appellant is not entitled to pay any additional tax to the respondent as withholding tax or credit interest for 1999 to 20, contained in Exhibit 807. The answer to issue 1 is therefore that from the available facts and evidence before this tribunal, the revised assessment notice dated 3rd December 2022 and the notice of refusal to amend dated 9th June 2023 up to the set aside and are hereby set aside. The issue 1 is therefore resolved in favor of the appellant's agency respondent. Issue 2, whether the appellant is entitled to the relief sought in the notice of appeal. From the notice of appeal filed on the 7th July 2023, the appellant says the following news. 1. The declaration that the revised assessment notice dated 3rd December 2021 and the assessment notice and the notice of refusal to amend dated 9 June 2023 are invalid and not disqualified. 2. Order setting aside the revised assessment notice and all right. 3. An order of perpetual injunction restraining the respondent from acting on or giving effect to the revised assessment notice and order, or seeking to take steps or any other action to the effect of recovering any part of the whole or the whole of the sum of 102,603,067 from the appellant, including seeking exercise of the respondent's power of defense. A straightforward answer to issue 2 as to whether the appellant is entitled to the relief sought in the notice of appeal is yes. In view of the conclusions already reached on issue 1, the appellant is entitled to reliefs 1 and 2 sought in the notice of appeal. Relief number 3, which seeks for perpetual injunction, is refused and struck out. In the final analysis, this appeal succeeds, and this tribunal will hereby make the following orders. A. The additional tax assessment on withholding tax credit interest for 1999 to 2014 is statute bound. B. The 21% penalty and interest computation by the respondent is in breach of section 74 of the Personal Income Tax Act as amended and is hereby set aside. C. The revised assessment notice dated 3rd December 2021 and the notice of appeal refusal for amendment dated 9th June 2023 in respect of 1999 to 2020 withholding tax of credit interest. Tax liability of the appellant are hereby set aside and being unjustifiable and excessive. There is no order as to cost. This is the landmark tribunal of this service.
The tribunal pleases. Honorable Tribunal, we are most grateful and we commend the tribunal's industry in arriving at this decision. We are really grateful. Mr. Chairman, please, I have one appeal, sir. I don't know if I can be heard. Okay. It's just for my name. It's just for my name to be added alongside Mr. Onyeka Iwogu's name as persons that represented the appellant in the judgment.
Your name to be added to who?
Alongside with Mr. Onyeka Iwogu's name as counsel that appeared for the appellant in the judgment.
Noted.
Thank you so much. Thank you. I'm most grateful.
Last on the cost P number C86 SSS and notice of 2024. Bomb bombing to oil Nigerian Limited and Total Internal Revenue Service.
Meet me this honorable tribunal. The name is Mowan Edwin. My parents is for their blood. We apologize for the absentia. Misrepresentation.
For one reflection, no, we have, your options, this is about response.
No.
The 17th of July, none of you appeared. You are not appeared. 17th of April. You conspired not to appear. What? For report of settlement, have you settled?
So, ordinarily, Mr. Chairman, the matter was supposed to be for the court of assessment. However, there is an.
Let's have it done. Let's have it done. Forward. Yes.
So I said ordinarily, according to the process, the matter was supposed to come up for the report of settlement. However, after deep introspection by the appellant, very deep level of introspection, the appellant thought it wise to adopt a different means for respect to the pattern for his child.
What is that dependence?
Mr. Chairman, we filed a notice to withdraw the appeal. Every tribunal for the ICAP applications. Damn lesson
5. You notice.
to withdraw. To withdraw the appeal.
The third one.
Mr. Chairman, our notice is dated on the 19th of May 2026 and filed on the 20th of May 2026. A notice is proportionate to Order 11, Row 1, and Order 14, Row 1B of the Tax Appeal Tribunal Procedures 2021.
14, Row
1B. And we are seeking just two prayers.
Yeah.
We are
So
seeking
what's
just
the name? Are you moving that place? No. Let's tell you. You know what you said.
I thought the tribunal was ready for me to.
Let's hear what you have to say. If she's opposing it, yeah. Yeah, yeah. You said you should before report of settlement and said appellant has decided to withdraw the appeal. Yeah, are you aware?
I was served
Okay, they said-
on Thursday,
I was served with what?
electronically on Thursday.
I was served.
Electronic. What's the one hit?
Oh, 28.
You were saying what?
With the notice of withdrawal, first, on Wednesday.
With what? Yeah, so,
Yes, sir.
Great.
20th.
So, were you taken by surprise?
I was taken by surprise
So we record you. I was taken by surprise.
to some extent.
Why?
Because as journalists are aware, this matter has been on for about a year now, if I'm correct. And I've been talking with the board at the Warri. And I was informed that the matter has been settled. I think I'm making that report. He said it was for us to file the notice of settlement. That was the point.
Terms of settlement.
In terms of settlement. They have come up with this one. I don't know. It's their matter. I don't know what to inform this one, so I cannot speculate.
You want to pay the tax liability.
The law allows them, sorry.
Are you opposing?
Yes, no, I'm not opposing, because the law allows them to withdraw. However, I will want the tribunal to take note of the circumstances of this matter.
Yeah.
The people that validated that they can, I mean, I think it, I don't know,
I think,
I think I should just hold it on there when you finish.
Are you opposing the
I am not opposed. But
So what do you want us to note?
I want to go to notice, going to this matter has dragged on. They have taken their witness. That's what I was going to like. People are putting it right. Someone has said, because it allows them to withdraw.
Exactly.
But the scope says that in granting the tribunal, the court, in granting that application to withdraw, yes, they should take in special circumstances, and they have alluded to it, even in their duty address. That's where I'm advising the tribunal to mind voice.
Madam,
Yes,
where do you stand?
because I'll be asking for substantial.
Are you opposing the application?
We are not-
If you are opposing the application, that's what we can rule, considering the tribunal will not consider the circumstances and the state at which they are referring. But if you are not opposing,
Okay.
we strike it out. But if you are opposing, let him move his application.
Okay.
You oppose, we rule on it.
Okay, I'm opposing. I'm opposing.
Did you buy a counter?
I know, all right, that's what I've said. I said,
Oh, you will just serve
I will
recent.
just say, even this one, the recent.
So you still want to have time to file. You can't.
The tribunal wants me to file, I think I'll do that.
No, it's not what you do for them.
We can't descend it on
Okay.
conflict.
Application is harmless.
Is that the?
So I now record you that I intend to.
I tend to oppose,
Yeah.
yes.
So moving.
You can move, you can move, you can just serve her, she's entitled for 3 hours.
He has said we move the application.
But you can't move it because she's
It's not
opposing. You want to run a counter.
Because I would have opposed already if it's
Okay.
allowed.
On points of law, you know you
Yes,
cannot
yes.
raise facts.
Yes, I will use the other case here, I'll just read those, what the law says.
So I intend to oppose the application. So, okay, move on, you can move the application.
Thank you so much, sir. So, Mr. Chairman, can I proceed?
Yes,
We have an application to withdraw our appeal. Application is dated the 19th day of May 2026. and filed on the 20th day of May 2026. Application 8 brought pursuant to Order 11, Rule 1 of the Tax Appeal Tribunal
Yes.
of the Tax Appeal Tribunal, which gives us the latitude to file this application, and also Order 14, Rule 1B. Of the same rule, it also gives us the right to file this application. Our application is seeking 2 definite prayers. The first one is an order of this Honorable Tribunal granting leave to the appellant to withdraw its appeal for the reasons contained in our affidavit.
Yeah.
The second one is an order of this tribunal striking out the appeal from its record due to the appellant's unequivocal intention to discontinue the appeal or the prosecution of this matter. The ground for which this application
Striking out.
Yes. Due to the appellant's intention to discontinue and no longer interested in pursuing the appeal, the prosecution of the said appeal.
Prosecution of this appeal.
Yes.
Yeah.
The grounds and reasons for which this is brought have been set out on the face of our motion paper. Our application is also supported by the 9th paragraph affidavit deposed to 12th paragraph affidavit deposed to Mr. Atagana Douglas. Atagana Douglas, Investigation Executive in the Office of Banwo and Kudado. Mr. Chairman, we.
You say the question by
Atagana. Atagana is spelled.
what you saying this is?
No.
Atagana Douglas.
Yes, Atagana is spelled A-T-A.
I've seen it.
How many paragraphs?
12.
No. Yes.
Mr. Chairman, we are relying on all the paragraphs in there. No. Application is also supported by a written address where the applicant has completed just one issue for the termination. And we seek to adopt that. As an argument in this application, for this application, and it says,
Whether one issue, okay,
yes, that's one issue.
no, no. Yeah, you adopt it for.
Yes, as arguments,
In this case,
yes, in this case. Mr. Chairman, if I may, for just the purposes of our deliberation,
of record or
still on record.
Yeah.
The issue is whether or not, or whether this tribunal ought to grant the appellant's application to withdraw the appeal and to strike out same as great.
Yes.
Application was not brought as a result of conjecture, but by standard rule of proceedings. And in accordance to Order 11, Rule 1 of the Tax Appeal Tribunal Rules,
You have already said so.
yes, which states that,
You already said so.
okay,
Let me answer it.
okay. We also refer this tribunal to the case of Babatunde and Pesta Limited. Two 2007,
Doesn't
Pesta 8 abbreviations.
Babatunde.
Yes,
Babatunde what?
versus Pesta P
Yes. P what?
A
P A
yes S T
P E or
A
A.
P A Pesta
Okay. P A S
T A
Pesta. Okay.
Limited.
Both it is
2007,
limited.
yes, Limited.
2007.
13
Yes.
NWLRO parts
Yes.
1050
Yeah.
113,
No, right.
where the Supreme Court held unanimously
Yeah.
that a party has the right to discontinue his action if he so chooses, as the filing of an action
So the writing of an action.
does not necessarily imply that the parties have irrevocably committed themselves to resolving their disputes,
Have irrevocably.
committed themselves to resolving their disputes by litigation. There is also necessary and significant to state honorably before this tribunal the withdrawal of
Yeah.
appeal
Yeah.
a significant part of our jurisprudence. They can be done in two phases, either with the leave of the tribunal or without the leave of the tribunal, depending on the circumstances surrounding it. The reason is because
Just a minute. With the leave of tribunal.
or without the leave. depending on the circumstances.
No, we cannot do
Surrounding the case.
it. Yes.
The reason is because the law sees the party instituting an appeal or an action as the dominus litis, or the owner of his rights.
Is the owner,
Is the owner of the said rights, which he has brought before the courts.
yeah,
And the court of law,
you need plenty of grammar.
I
I expect the important area I want us to address us is what order to make. You can withdraw at any time, but what order can we make at this stage of the proceedings?
so the order,
That's the area I want you to address.
okay,
You have moved the motion.
You understand me? Is it in your address?
yes, it's in the addresses in the motion.
What order to make at this stage of the proceedings?
Yes, to strike it.
So you can say you have adopted your right. And that is the important aspect. What order to make? Order striking out or dismissal.
Striking that.
You have made it in your address.
That's all. So that's
But now let's say. Okay, let him run up. Run up your submission. Like one sentence. No, don't go back to the address you have filed.
Please,
Just summarize your-
both the better.
Maybe you urge the tribunal to grant their.
So based on the foregoing and the agreement canvassed so far, it is our prayer that
The one from the following, we urge the tribunal to grant our appeal. So that is remove
as per the
This is.
therefore, we urge the tribunal to grant our appeal.
I was gracious.
Yeah. No, what's it? What's your name?
Mashone.
What's your name?
Yes. I'll post this motion for withdraw. Striking out this suit. On grounds of, I have it just on I cannot, since I did not find any counter and restricted law. Point of law, so I'm referring to tribunal.
Yeah.
Okay, they put down here. They cool down.
Just a minute.
EKUDANO.
Case of
Ekudano, EKUDANO. Against
Ekudano.
Ekudano.
Okay, DO.
EKUDANO.
DANO. Ekudano.
Yes, against Keregbe.
Against KE.
REGBE.
KERE.
GBE.
Yes.
Reported in 2008.
Yes.
JELR.
J.
ELR.
Which law report is this?
Supreme Court is
JB.
It's JE.
JELR.
I think it's, I don't know, but Supreme Court is a case.
No, I mean the report.
That's
It's
what,
finished report.
that's why I couldn't say exactly what JES are doing. But it's there if you go check it. Yes, I've read it. I'm going to quote now.
I've never seen this report.
It's the Supreme Court.
JELR.
Just go on.
What page?
5454.
545.
Yeah, 5458. I'm sorry. 5454. I'm sorry.
545.
4.
Make up your mind.
54544. Supreme Court. That's how it's reported.
54.
And then 544. Yes, 544. Supreme Court. That's how it's reported.
Yeah.
Yeah, the court stated that the request for discretion for discontinuance. The way the request for discontinuance.
Very stated that.
Where the request for discontinuance
Yeah.
is made after date for the hearing of the suit. Is made after date for the hearing of the suit. The plaintiff may discontinue only with leave of the court. And subject to conditions that may be imposed by the court. In granting the request for discontinuance, the trial judge may order that the case struck out. Or make an order for outright dismissal. Order for outright dismissal of the suit. Whichever order the court makes,
In this case, tribunal.
yes, this case tribunal, will depend on all the circumstances of this case. And an appellate court will not ordinarily tamper the trial court's exercise of such judicial discretion. Not ordinarily tamper with the trial court's exercise of such judicial discretion. I also like to support it with Ajayi and against Ogunsi.
Ajayi.
Against Odunsi.
ODUNSI. Citation.
Supported in 1959.
Yeah.
SCN LR, Supreme Court Nigeria Post Report, page 496. SCN LR.
Yeah. Page.
196.
196.
From these authorities, it is clear that the order the trial, I don't know what tribunal decided.
Madam, from this authority,
Yes,
all this may is the creation of the tribunal.
yes, that's actually, yeah, Ministry of-
I want an authority that says sharp. No discretion. Dismiss or strike out. Is it it?
Yes, from that's what the authorities are giving, and it says, it's clear that in order to.
You saying discretion is discretion.
Mm,
May. Judge may order that the case be struck out or make an order.
But in doing that, you take into the second.
Whichever order the court makes will
Yes.
depend.
The circumstances.
Discretion, yes, on all the circumstances of the case.
Bringing having the circumstances in view.
Yes.
Yes, that's what.
Because each case differs.
Yes. So I'm bringing the circumstances, you have handled the case of, you saying, well,
Yeah. What I want you to do,
okay.
help the tribunal, tell us, strike it out.
That's where I was going to.
Or dismiss it.
I was going to accept from these two cases.
Now, yes, they said, tamper with the entire space, maybe the circumstances now.
The circumstances, I should talk about the circumstances.
No. Go ahead.
From these two authorities,
Yeah.
it is clear that the proper order
Yeah.
to make in this matter
Yeah.
the dismissal of this suit,
Of this appeal.
of this appeal. Taking into consideration the circumstances of the appeal and the stage it has reached.
Yeah.
And I also like to say, I'm also saying that cost follows event. I'll be asking for cost. Substantial cost.
What makes this substantial?
The case has lasted for a while.
I say, how much is substantial?
600,000.
That is substantial.
No, it's taken to, I'm sorry, okay, off record.
Where of record?
Okay, I am supposed to get remunerated from this matter. The way it is going, I'm not sure I will.
But then you are still entitled to your protection fees. You have been coming.
Yes, I've been coming.
You've done your work.
Yes.
With cost company.
You will not understand because I'm supposed to have 10% of whatever came out. So how am I going to determine? And I'm not aware, so that's between me and the operator. That's why I said operator.
You have been recorded.
That's why I'm putting that. It's a bit clumsy right now. Yes,
I understand you.
Consistently, we're just waiting for settlement, and I don't see why they cannot draft
5
settlement.
terms of settlement.
I'm surprised.
And you didn't even know what was happening.
Yes, so I don't know. So I think
Are you discussing with our client behind her back?
yes, that's what we
If
So we,
you are doing that, that is
no, we are not discussing behind our back.
because you know that we have a council already. There's no discussion that should be had with the litigant without
The council.
involved.
But she's not aware now.
We are not discussing behind our back.
It's not the case that you came and you were surprised that they said they were settling. It means they are trying to settle, they are discussing behind you.
We're discussing behind that one. I think we provided an official means for communication. I know that we reached out, they reached out from that means. So
The outcome she's.
Mowa, when did you take over this case?
I just.
Have you always been in this case? I don't see your name.
No.
I just.
I can't see your name.
The first time.
I was with.
You metamorphosed from
And with our You just said you have moved on.
Now that's one.
So you are, yeah.
It changes.
And even the amount, what's the amount of those,
It's 100 and something minutes.
I think.
100 and something, yes, I was 100 and something somewhere.
So,
At the point,
I would say for
at the point, they said, they were coming to 5 games of settlement.
how come?
5 games of settlement. On the 22nd of January. The world day.
Well,
I'm happy to come to the tribunal that we have, to settle this matter. And we need another adjournment to enable us file our next subsection.
That is the record. So,
And you were not
On the
going to
22nd
the picture.
on the 22nd of January.
she's aware of this.
Tita, you want us to watch Allah? I'm
No,
aware.
no worries.
No, what I'm saying, I'm aware of that settlement.
No, the terms of settlement.
In terms of settlement, that's where the problem is.
Where is the terms of settlement?
Should I respond to her?
No.
Or should I respond to
The
the
terms of settlement.
Okay,
The case was adjourned then for,
so,
to file their terms of settlement.
so with respect to the terms of settlement. It wasn't as a result of our own,
On the 20th of February, there was no appearance by the appellant. Omasone was here. Omasone said this case was around there for a proper settlement. During the week, counsel to the appellant called me and forwarded a draft of the terms of settlement. And I expressed my concerns after going through the terms. And forwarded it to my colleague at the legal unit of the respondent. I am yet to get a feedback. I'm asking for a further date for a report. You can see that the terms have been drafted by your client. And sent.
we've drafted the sense,
And sent. Yes.
so they are the ones keeping.
So,
it.
so the terms are still with them.
They are the ones keeping it on.
And you are withdrawing.
So we just want to, we are tired of, making expenses coming to,
Because that would be at
in prosecuting this matter and all of
Then
that.
on the
So that's
20th of March, I'm coming, 20th of March was a problem of the day. The case was adjourned to 17th of April. 17th of April, none of you are here.
no appearance.
But what's happening to the terms of settlement? They are with your client. Issue to your client.
It's not. Sorry, my lord.
Issue to your client.
They
From our records.
file it.
From our
They
records.
draft, what they drafted was, they sent it to me.
Yes,
I, on my own,
yes.
forwarded it to me, because I just said I should sign. I said, no,
You forwarded it. That's
I
what
forwarded
our
it.
records, yes.
then my colleague said she's not aware, that's legal unit.
Aware of the settlement.
Yes, but ordinarily, they look at it, if it's okay, I'm go, they are able to sign.
Have they gotten back to you on,
Yes,
on the settlement, on the draft?
no, they got, but there's nothing stated there in the settlement, no amount, there's nothing stated there.